All right, well, good evening, everyone. It's 4 o'clock, so we'll get started. Welcome to week number 3 for PPA 500. I hope everyone is doing well, and it's nice seeing you again. I'll keep my camera on as long as I don't have connectivity issues. If connectivity issues arise and you see my camera go off, you know that's the reason. But if so far so good, I'm teaching from home today, and so sometimes my connectivity can be a little wonky, and so I just want to make sure in case it does get bad. If I turn off my camera, then usually we can save some bandwidth and relieve ourselves of those connection problems, but we'll see how it goes. But this is week number 3, and so thank you all very much for your posts in Canvas essay number 1, looking at James Madison's arguments in Federalist Paper number 10. I've gone through and reviewed all those. Very happy with the discussions. I think everyone did a very nice job. They were comprehensive, but they weren't overly long. They got to the point, and they certainly showed a general understanding of what Madison was talking about, and a really nice comparison of the Madison's time to our time in terms of the presence of factions. And anytime we try and overlay our experiences on top of the experiences of the framers, and their experiences obviously were over 200 years ago, it can be a little dicey. As we had talked about before in our last class, the terminology that we use is different than the terminology that was used by the framers. And so sometimes when we do that, it's kind of difficult because we just have different semantics than what the framers use. And so it is somewhat difficult to talk about, well, is our point in time, is our time period more factionalized than Madison's? But I think you did a really nice job with it. And I think one of the things that is kind of different for us today in terms of factions is that there tends to be disparity in the resources of factions today, a greater disparity than perhaps what we saw back in Madison's time. And so we have some special interest groups today that are very well funded, that have prestigious members, that have very strong connections in Congress as well as state legislatures. And so some of those interest groups certainly have a lot more power and a lot more influence than interest groups that lack those types of resources. Interest groups today really generate a lot of their power from, number one, obviously their monetary resources. And so if they have a lot of money that they can use to contribute to political action committees, that will certainly help them achieve their policy goals. They also generate a lot of their influence from the types of members that they have. And so you think about an interest group such as the American Bar Association, members made up of lawyers. Congress is made up primarily of lawyers, both the House as well as the Senate. And so that kind of gives them a natural leg up, if you will, on some other interest groups just because of the nature of their membership. Also, in terms of membership, the size of the membership can also have a big impact upon the resources and the influence of those interest groups. So you think about our largest interest group we currently have here in the US, which is the AARP, the Association for the Advancement of Retired Persons. They are the largest membership of any interest group that we currently have. They can actually tell a member of the House of Representatives, well, your congressional district that consists of 700,000 constituents. Of those 700,000 constituents, 20% of those constituents belong to the AARP. And not only do 20% of your constituents belong to the AARP, but that 20% is the 20% that is far more likely to vote than other demographic categories. And so that really does carry a lot of weight with members of Congress whose primary motivation is to get reelected. And so there is this great disparity between factions today that perhaps we didn't see quite that same disparity in resources back in the time in which Madison was writing Federalist Paper number 10. But for our next Canvas essay, just keep doing what you did on Canvas essay number 1, because everyone did very well on that one. And in Canvas essay number 2, what we are looking at is we are looking at accountability and ethics. So we are going to draw upon the information that we're covering tonight, and you'll be looking at the ASPA Code of Ethics and those 8 principles in the ASPA Code of Ethics that we'll cover in class tonight. and then pulling out 3 of those 8 principles that you feel would be most difficult either for you or for your organization to implement, and then discuss why those 3 principles may be difficult to implement. So same ground rules apply, 2, 3, 4 paragraphs for your initial post, and then maybe a paragraph for each of the responses to 2 of your classmates. Now, in terms of the due dates and when you'll do all this, obviously, if you can post your initial post as early in the week as possible, that would be helpful because that will then allow your colleagues to have something to respond to and then have your 2 response posts done by class next Tuesday. So that's Canvas essay number 2. And then also next Tuesday, you have the draft advancement to candidacy form that is due. I've gotten several of those already. The ones that I've looked at have all looked great. The course sequencing has been good. The course selection looks good. And so the feedback I've been giving on those is just course sequencing looks good. It's, pretty much ready to go whenever you are ready to advance candidacy, hopefully by next semester. But do make sure to get that turned in by next Tuesday. If you are not in the MPA program, as we have previously discussed, just send me an email and just say I'm not in the MPA program, and then I'll waive the draft advancement requirement for you because chances are you already advanced the candidacy in your home department. So that's what's due next Tuesday, Canvas essay number 2, and then the draft advancement to candidacy form. The initial skills self-assessment, people have already turned that in, and thank you very much. I've gone through all the initial skills self-assessments. They came in by about, I'd say maybe 2:30 today. If it came in by 2:30, I've already taken a look at it. Again, those are just credit, no credit, and so there are no wrong answers on that. And so I probably just thanked you for your good, for your clear assessment. That initial skills self-assessment now will be the first document that will go into your student learning portfolio. So hold on to that initial skills self-assessment. That will go into part 1 of your student learning portfolio, along with the final skills self-assessment that you will do as the last thing you do in PPA 697 directed research. If you are not in the MPA program, I thank you for doing the initial skills self-assessment. Obviously, you don't have a portfolio requirement like MPA students do, so you don't have to hang on to it if you're not in the MPA program. Okay? But again, thank you very much for those assignments, and we are moving right along. And yes, the due dates for the Canvas essays are midnight by Tuesday. And so all my due dates are always by midnight. Okay. All right. I do know that there's a little something going on tonight that's called a presidential debate that I'm sure a lot of people will like to watch. So hopefully we'll be able to get out of here a little early tonight so you can go and watch the debate if you are so disposed. But what I'd like to do tonight is not talk as much as I did last week. I know I talked a lot last week. We actually almost ran overtime, or we did run overtime, I guess, last week. And so what I'd like to do tonight is to incorporate some breakout groups into our session. So what I'm planning on doing is in the first part of class tonight, talking with you about accountability and ethics in public administration and provide you the information that you need to then go forth and do Canvas essay number 2. Then we'll take a break. And then after our break, when we reconvene, we'll break up into breakout groups. And I have a breakout group exercise for us to do. And we'll work in our breakout groups probably about 30 or 40 minutes. Then we'll reconvene as a class. Each group will then share the answers that you came up with, and we'll kind of compare the answers between the groups. And then I think we'll probably call the night at that point in time. Because next week, in next week's class, the first half of the class, we'll be bringing in Kelly Janicek from the University Library. And so she'll be talking to you about all the tips and tricks about how to do research in public administration using all the resources that are provided at the University Library. So she'll probably spend about the first hour and a half or so of class next week doing that. Then once Kelly is done, then we'll spend the remainder of our time getting more into the issue of differences between public and private organizations, highlighting ways in which those organizations are similar and then ways in which those organizations differ, for the purpose of really suggesting why we study public administration differently than we study private organizations, and some of the ways in which we do study public organizations differently than in the private sector. So that is then the goal for next week, and that's the plan for tonight. So accountability and ethics in the first half, and then breakout groups in the second half of class. Before we get into accountability and ethics, are there any questions or clarifications or anything that's needed? Okay.
I have a question.
Sure, go ahead.
I remember for the intro, you mentioned that you were going to open up the assessment as well today.
That's a good point. Thank you for the reminder. Yes, I will do that. We are now 2 weeks from the midterm assessment due date. So thank you for the reminder. As soon as we're done with the class tonight, I'll go and make that available. And then you can start working on that midterm assessment. So thank you for that reminder.
Thank you.
Yep, absolutely. Okay, let's get into our discussion of accountability and ethics. And this is obviously a very important topic to cover in an introductory course such as this. And the way in which our accrediting body, NASPA, allows programs to deal with ethics in their curriculum is to deal with it in one of two ways. Either programs can develop a standalone core required course in ethics that every student must take, or the second alternative is that they can sprinkle ethics throughout their entire core and elective curriculum. We have chosen that latter option. So you get a week on ethics and accountability here in the 500 course. You'll talk about accountability and ethics again in budgeting within the context of managing public funds appropriately. You'll talk about ethics and accountability once again in 577 human resource management, where you talk about how you deal with employees and how you engage in human resource management functions on an ethical basis. In their 660 organization theory class, ethics will come up again, as you'll have a module, a section of the course on ethical organizations and how to develop and create these ethical organizations and codes of ethics for your public or nonprofit organization. 670 policy analysis, obviously there are ethical implications there in terms of the distribution and oftentimes the redistribution of resources across different segments of society, and how to do that in a fair and equitable manner, how to maintain social justice and social equity through the distribution of those resources. And then in 696 research methods, you can't talk research methods and program evaluation without having a segment on ethics. Whenever you are dealing with human subjects, obviously ethics are extremely important, especially if you're dealing with at-risk populations. So in your 696 course, you'll talk about some of the safeguards that you can put in place in doing research and program evaluations to make sure that you are treating people fairly, treating people in an equitable manner, and that you are recognizing and protecting people's autonomy, beneficence, and justice. And you'll talk about those three principles of ethics when you get into 696. And it's not just our core curriculum where we deal with this issue of ethics and accountability. Depending on the elective courses you take, you'll also run into this topic again. One of our very popular elective courses is 571 Leadership. Obviously, when you talk leadership, you also have to talk ethics because you are talking about interfacing with individual employees. So ethics becomes a big component there. For those of you who are in the option in urban affairs, ethics is a very big component. Equity is a huge component in the way in which our program deals with urban affairs. If you take the seminar in urban affairs with Dr. Martin, he really places a big emphasis on ethical implications of running cities and the equity that is necessary in terms of distribution of resources in metropolitan areas. And so even through our elective courses, you will get this exposure to ethics. But since this is the first course in the MPA program, this is our first exposure to accountability and ethics in a Master's of Public Administration program. So it's important we spend a little bit of time tonight talking about some very basic issues, such as what is accountability? We always say we want to hold public administrators accountable for their actions. But the question is, what is accountability? A very basic definition of accountability is a relationship between people and things. For us here in an MPA program, the people will be our public administrators. So these are our bureaucrats, these are our administrators. And we hold them accountable for how they interact with different types of things. And so things such as financial resources. So how do they manage their budgets? How do they award contracts? And here in California, we typically have a competitive bidding process depending upon the value of the contract that's being awarded. And the reason why we have this competitive bidding process is not just to do bidding efficiently, but it's also to make sure that we don't have favoritism and nepotism that's involved in the awarding of contracts. We have a very lengthy public contract code here in California. And the public contract code calls for, oftentimes in competitive bidding, using the sealed bids. And so a government will put out a request for proposals, an RFP, and then will solicit sealed bids. Contractors will submit their bids to the government. There will be a preordained day and time at which those bids will be open. The opening of those bids will be done in a public setting. All of those bidders, all those contractors are invited to come and watch the opening of those sealed bids to make sure it's all being done above board and all being done in a very fair manner. Then when those bids are open, then it's the requirement of the government to award that bid to the lowest, what we call responsive and responsible bidder. A responsive bid is a bid that addresses all of the requirements in that request for a proposal. And so if you've got a request for proposal for constructing a new city hall, and part of the construction of that city hall, you want to include, we'll say, offices for each of the city council members, and that will all be part of this new city hall. And then if the bid comes in and the bid does not have construction of those offices as part of the bid, then the bid is deemed to be non-responsive because it does not appropriately respond to the request for a proposal. Responsible refers to the bidder themselves. Any contractor that is awarded a bid by government must be deemed to be a financially responsible bidder. And to be financially responsible, it means that your organization, your firm must be registered with the California Department of Industrial Relations, otherwise known as the DIR. So you need to have a DIR number, and you need to include that DIR number on your sealed bid. In addition to that, not only does the contractor need to be registered with the Department of Industrial Relations, but all the subcontractors that will be used also need to be registered with the DIR. So what contractors will do, obviously, is they will farm out some of the projects such as plumbing and electrical work and cement work. They'll farm that out to subcontractors. So all the subcontractors that are being used must be listed in the proposal. They must all have DIR numbers. They must all be insured and bonded just like the contractor. That makes them fiscally responsible. So you choose the lowest bid that is both responsive and it's from a bidder that's considered to be financially or fiscally responsible. That's this competitive bidding process because we want to make sure that we are spending money, public money, in a very fair and unbiased way, so there's no favoritism or nepotism that's going on. So that is how we kind of manage this relationship between governments and contractors in terms of the spending of public money. Another aspect of this relationship between administrators and things, we look at the relationship between administrators and people. So people within the organization as well as people outside of the organization. So we hold administrators accountable for, as we talked about last week, not violating the constitutional rights of citizens that they are dealing with. And we also hold them accountable for not violating the civil service protections of employees and also to not violate the collective bargaining agreement provisions that also are afforded to those employees as well. So it's really this relationship between administrators and the types of people and the groups, as well as the money that they are trying to manage. Accountability really is the foundation of bureaucracy because it allows policymakers to control the actions of administrators. And this is an important thing. Administrators, as we all know, are hired based upon our knowledge, skills, and abilities. And that's a good thing in a career civil service system. That means that we are hiring experts, we're hiring people who have the requisite knowledge to do the job. However, since we're hiring people based upon their KSAs, as we call it, those administrators do not have a direct connection to the voters. And the voters cannot hold those administrators directly accountable for their actions. So the conduit, the connective tissue between the public and administrators will be policymakers, those elected officials. Elected officials can be held directly accountable by the voters, and then those elected officials will hold administrators directly accountable for their actions. So it's kind of like this in research we call the path analysis, in that the accountability for the administrators flows through the elected officials. So it really is elemental to have a system of accountability in place whereby elected officials can hold administrators accountable for their actions. The problem with accountability in the public sector is there are a lot of negative incentives associated with elected officials getting involved in overseeing administrators and holding administrators accountable. Accountability has very negative connotations because accountability usually is related to uncovering problems. And elected officials really do not want to be held accountable for these problems that are emerging because of the actions of administrators. And so, unfortunately, policymakers, elected officials will oftentimes keep their distance from their accountability job. They keep their distance from overseeing the actions of administrators. And whenever elected officials are very reticent to engage in the oversight that's necessary to hold administrators accountable, you kind of lose this clear chain of accountability. But in our system of government, the elected officials are supposed to oversee the actions of administrators. So as administrators, we are held accountable by members of a legislature, whether it be Congress at the federal level or whether it be a state legislature at the state level. However, the duality is we also operate within an executive branch, which means we are also under the auspices of the chief executive, whether it be a president at the national level or a governor at the state level. So this is this many masters argument that we talked about last week that we have because of our system of separation of powers and federalism. So our actions as administrators, we are held accountable for our actions through the oversight function. Legislatures have the primary job of overseeing the work of administrators. The problem with oversight, however, is this principal-agent relationship. The principal-agent relationship, the principal oversees the agent. You would assume that the principal, the overseer, will have access to all the information that they need to properly oversee the actions of the agent. So the principal in this regard is, for example, a congressional committee, members of Congress. The agent would be a federal department or a federal agency. So when Congress conducts its oversight, it does it in a variety of different ways. One way that Congress will conduct oversight is it'll do it through legislative review committees. And so you'll have committees that will call in heads of agencies and have heads of agencies come in and testify regarding different issues going on at their agency, how effectively the agency is implementing policies and programs, and will actually testify to what's going on a daily basis in that agency. And so we have legislative review committees that conduct oversight. We also have oversight conducted by appropriations committees through the appropriations process. So you know that Congress controls the power of the purse strings. Congress controls the appropriations. They control passing the federal budget. Since Congress has the power of the purse strings, Congress can oversee the actions of administrators by increasing appropriations for an agency, cutting back on appropriations for an agency, either opening up or squeezing those purse strings. So through the appropriations process, in order to get appropriations for next year, sometimes agencies will be called in to do what we call sing for their supper. So they'll be brought in to testify in order to free up those appropriations. So there's an oversight that's done through the appropriations process. Now, if you know anything about the way the federal budget process works, the federal budget process kind of works in two different tracks. There's an appropriations tract, and then there's what's called an authorization tract. The appropriation tract is for discretionary spending. And in our review of the Constitution, we saw that there is a limitation on Congress, that Congress may not withdraw money from the Treasury except in the furtherance of an appropriation. That basically they cannot take money from the Treasury and spend money until they first appropriate that money. And appropriation is just basically saying, this is how we plan on spending the money. So that appropriations type of process, that's for what we call discretionary spending, spending that Congress has direct control over. So a lot of the appropriations to federal agencies and departments for just kind of general program administration, that tends to be discretionary spending, and that then goes through this appropriations process. However, there's a lot of spending in the federal budget that is non-discretionary. It's mandatory spending. It's spending that Congress does not have direct control over. So you think about something like an entitlement program. With entitlement programs such as Social Security, for example. Social Security is an entitlement program, which means it's eligibility based. So people become legally entitled, legally eligible for these benefits when they meet the eligibility criteria. So when they are fully vested, when they reach their retirement age, they then become eligible for those benefits. If you are legally entitled to the benefits of an entitlement program, it is unlawful for Congress to deprive you those legally entitled benefits. If Congress wants to reduce spending on an entitlement program, they must, instead of appropriations, go through the authorization process. They must change the eligibility requirements through the authorization process. So if they want to spend less money on Social Security programs, they're through the authorization process, will have to go in and change the retirement age, for example. Increase the retirement age. If you increase the retirement age, fewer people are then eligible for Social Security benefits, and then less money is being spent on Social Security. So that's kind of this authorization type of process. So there's oversight of agencies going on through the authorization process, because whenever Congress is going through authorization and changing eligibility requirements, they are going to call federal agencies and departments in to testify to provide them with information about how they should change those eligibility requirements. So there's a lot of oversight that goes on with legislative bodies. But when they are overseeing agencies, they are in the middle of this thing called a principal-agent relationship. As we said, you would normally assume that the principal, the overseer, would have the information and could then use that information to oversee the actions of the agent. We all know in the public sector that usually there is information asymmetry, in that the agencies are the ones who have the information. Who knows best what's going on a daily basis in a federal agency than that federal agency itself? When you have that type of information asymmetry, and the information resides with the agent instead of the principal, it is then up to the agent to decide what information to provide to the principal and how much information to provide. That is what we refer to in the principal-agent relationship as a moral hazard. So the moral hazard for an agency or a member of an agency is they have to make this ethical decision about how much information do I provide to Congress. The more information an agency provides to congressional overseers, the easier it is for those congressional overseers to strictly oversee the functions of the agency, because they now have the information to ask the right types of questions to kind of hold the agency's feet to the fire. So there's a built-in disincentive for agencies to provide that information to Congress. That moral hazard about, do we give the information, do we withhold the information, that's a problem with the principal-agent relationship. So Congress does not always have adequate information to do its oversight function and to hold administrators accountable for their actions. Another flaw in this oversight process is sometimes the use of executive privilege. And we have seen this in the past few administrations, where Congress, a legislative review committee, will call in agencies and members of agencies and to kind of grill them, oftentimes grill them in a public setting. And you have the possibility that the president could exert executive privilege over the testimony of these executive officers. So it could say, I'm going to exert executive privilege, and so therefore they cannot testify to Congress on this topic or on this issue. When that happens, then you end up with a legal battle, and you end up with a legal battle between the executive branch and Congress over what information the president can shield from the oversight of Congress. And so, even though Congress has this oversight responsibility, sometimes the waters get a little bit muddied, and it's difficult for Congress to truly do their oversight functions. It is very important for us to make sure that we have a system in place whereby overseers like Congress can oversee the actions of administrators without taking away all the flexibility and latitude from those administrators. We want to make sure that we can control the actions of administrators for the purpose of accountability, but still free those administrators up enough so that they can do their job in an effective manner. So their job's not just done, but their job is done well. Sometimes when we have too many and too stringent accountability measures, it can inhibit bold action on the part of administrators and also make it very difficult for us to attract new talent into the public sector. We'll talk in a couple minutes about the ethical upgrade shock that sometimes occurs when people move from a private sector organization into a public sector organization. And if you have gone from the private sector into the public sector, you've probably experienced this. You go into the public sector and suddenly you have all these audit requirements. You have all these accounting requirements. You have all these stipulations you have to adhere to that perhaps you didn't ever think about when you were in a private corporation. So there really is very much that ethical upgrade and can depress the likelihood of someone making that jump from the private to the public sector. If you've read that chapter on accountability and ethics in the Kettle textbook, I think that Kettle does a really nice job of laying out for us 3 different approaches to accountability over the years that we have taken to try and ensure the accountability of administrators, as well as 3 different types of accountability, if you will. So in the chapter, Kettle talks about these 3 different approaches to accountability. Says the first approach to accountability in the public sector was what was known as the legal boundaries approach. And this kind of dates back to the whole idea of the politics administration dichotomy in that study of administration article by Woodrow Wilson back in 1887. In a future week, we will go through Woodrow Wilson's article. We will deconstruct it and dissect it. But for our purposes now, for understanding the topic tonight, what Wilson essentially says is he says, if we can separate out politics and administration, we can then focus on administration. And administration really is what he called the business of government. So if you can take politics out of it, you can look at administration as a business, and then you can become more efficient in the way in which you are administering programs. So it was an argument for this dichotomy, this separation of politics and administration. When you have this politics administration dichotomy, you have a political side of the equation, and that political side of the equation belongs to elected officials. This is where elected officials formulate policies, they create laws. So the policy formulation occurs over on the political side. And then on the administrative side, where you have the administrators, they then execute and implement those policies. So policy formulation on the political side, policy execution over on the administrative side. The implication here for ethical adherence is that when you have this delineation between politics and administration, if you have administrators who are crossing that boundary, and you have administrators who are going over and working on the political side and getting involved in policy formulation, that could then be an ethical violation. They're kind of working outside their lane. And when administrators become political, that is a clear indication at that time of an ethical violation. And on the flip side of the coin, if you have politicians who are getting involved in the day-to-day implementation of a policy that's getting them out of their political lane. And that also then could be an ethical violation. So ethics were pretty clear. And the understanding of ethics, politicians stay in their lane, administrators stay in their lane. You have these legal boundaries between politics and administration. But when we do talk about the Wilson article, we will recognize that it was written in 1887, and about 40 years after it was written, public administration scholars started to take issue with it. And they started to take issue with it because they realized very early on there was not this stark difference between politics and administration. Administrators get involved in policy formulation. They contribute to policy formulation. They contribute to policy formulation through things such as providing advice to elected officials as they are writing laws, writing the rules themselves that will govern the implementation of these pieces of legislation. And so there really was very much a blurring of the lines between the political and the administrative world. And so the second approach was the political challenges approach. The recognition that this clear line of demarcation between politics and administration was not a sufficient definition of what is considered to be ethical behavior and what is considered to be unethical behavior. And it really did raise the question, can we enforce ethics at all when you have this bleeding over of politics and administration? How can you say this is a proper role of an administrator? This is a proper role of a policymaker, an elected official. The current approach to accountability, Kettle refers to as the evolving policy problems approach. The current approach recognizes the contextual nature of accountability in ethics. It recognizes that every organization has its own unique organization culture. What may be considered to be ethical behavior in one organization culture may not be completely ethical in another organization culture. In order to define and enforce ethical principles, we have to recognize the different cultures in each organization and then develop codes of ethics in accordance with those individual organization cultures. This is very much in line with my favorite answer to every question, which I warned you about on our first night together. It depends. So enforcing ethics will depend upon the context of that situation. Now, certainly there are some basic parameters of ethical behavior that cut across all organizations. If you are using public resources, resources from your position for private gain, today we would certainly consider that to be an ethical violation. In the late 1800s and the early 1900s, we may not have considered that to be an ethical violation. If you're familiar with the political machines that ran a lot of our large cities in the late 1800s and the early 1900s, one of the strongest of those political machines was one called Tammany Hall. And Tammany Hall basically ran New York City for many, many years. The Tammany Hall political machine really did blur the lines between politics and administration. And I think that's probably best characterized by a member of Tammany Hall by the name of George Washington Plunkett. And there is a great book called Plunkett of Tammany Hall. And in Plunkett of Tammany Hall, it's basically the memoirs of George Washington Plunkett and his time in Tammany Hall. And he kind of makes this really interesting argument to us that we kind of find weird today. But he makes the argument that there is what he calls dishonest graft and there's honest graft. So there are two types of graft, dishonest graft and honest graft. And we know graft today as being synonymous with corruption. So he's basically saying there's dishonest corruption and then there's honest corruption. So dishonest corruption would be, just taking money from your organization, stuffing it in your pocket. That's embezzlement. That's dishonest graft and corruption. So he kind of acknowledges that. But he said there's this other type of corruption known as honest graft, honest corruption. And he gives us an example of that. He says, let's assume that in my job in City Hall, I get wind of the fact that the city is going to buy up these lots of land for the purpose of creating a city park. Based upon that information, I then go out there and I buy this plot of land at a very low price. And then I wait till the city wants to build the park, and then I sell it to the city for a much higher price. He said, basically, I've done nothing wrong. It's what he calls, I seen my opportunities and I took them. Now, today, we would think that to be dishonest. We would think that to be corruption because he was using information that he got as part of his duties as a public official, as a public administrator, and using that information for private gain. And as we'll see when we talk about the 8 principles in the ASPA Code of Ethics, that's one of those principles, to not use public resources for private gain. You're supposed to put public interests above private interests. But back then in Tammany Hall, that was a common practice. And he would argue there's nothing at all wrong with that. In those political machines like Tammany Hall, you didn't get your job based upon your knowledge, skills, and abilities. It was the era of spoils. And so you got your job basically based upon, could you round up enough votes for the elected official? How well could you work toward getting someone elected? If you were successful at getting someone elected, then to the victor go the spoils. And so you would then get a city job from that person that you helped to get elected, irrespective of your knowledge, skills, and abilities, irrespective of your quality of character, any ethical type of training you've had. That none of that matters. All that matters is you belong to the right political party and you supported the winning candidate. So we saw a lot of that in this time of political machines. And so we really have this blending of politics and administration. And so for many years, it's been difficult for us to have a good, coherent set of rules and regulations that administrators must follow. Fortunately for us in our current system of civil service, the majority of our current system revolves around career civil service. It's an era of merit. So we are hiring people based upon their knowledge, skills, and abilities. We are kind of taking that partisan element out of the selection of who works for government. But in our current approach, we have to recognize that different cultures exist at different organizations. And so we have to tailor our ethical approaches to those specific cultures in those specific organizations. So just like our discussion of federalism last week, where we said federalism is very much contextual today, well, ethical adherence also tends to be contextual as well. And as we go through this class, once we get to the end of our time together, one of the trends that you'll take with you is that in the development of public administration, in our study of public organizations, we have learned that we have to be contextual in understanding how public organizations work. They are really no longer those universal laws and maxims. Now it really depends upon the situation in which we find ourselves. So when we are holding people accountable, what are we holding them accountable for? And that speaks to these 3 elements of accountability. So whenever we say we are holding administrators accountable for their actions, most of the time we are talking about fiscal accountability. We are holding agency officials accountable for how they spend public money to make sure they're spending public money the way in which that money was supposed to be spent. They're spending that money in the legally appropriated manner in which they are required to spend that money. They are only spending that money in those areas on those legally allowable types of expenditures. And that's called fiscal accountability. And usually whenever we see an ethical violation, a very high profile ethical violation, it usually revolves around fiscal accountability. And so you think about something like the City of Bell scandal, and you probably heard about the City of Bell scandal several years ago. In that scandal, what had happened is you had city officials who were paying themselves exorbitant salaries to the tune of you had city leaders, city managers who were making over $990,000 a year. You had a chief of police who was making almost $800,000 a year. And the way in which they were doing that is they were assigning themselves to pretty much non-existent committees and then paying themselves for attending committee meetings that actually never really happened. So you could have yourself assigned to 20 different committees, These were all kind of shadow committees that really didn't do anything. They never had any meetings that were actually held, and you would pay yourself, or the city would pay you for going to these committee meetings that never actually occurred. And so that's a problem with fiscal accountability. They were taking public funds and they were redirecting them toward private gain. Certainly, that money was not supposed to be appropriate to go into the pockets of these city employees, especially in a city like Bell, where you had a medium income level of somewhere around $30,000 a year, yet you had city officials making in the hundreds and hundreds of thousands of dollars a year in salary. So that's an example of a violation of fiscal accountability. The second type of accountability, if you will, is what's called process accountability. In process accountability, we are concerned with how agencies are performing their tasks. So basically, in process accountability, we look at how agencies are implementing the policies and the programs that they are required to implement on a daily basis. So this sometimes gets at the issue of efficiency. So how efficiently are they implementing these programs? A program is going to fail if it is not implemented efficiently and accurately. So this really looks at the implementation, the process that agencies go through on a daily basis in implementing these policies. Then the third type of accountability is program accountability. In program accountability, we hold agencies and administrators accountable for the impacts of the programs that they are implementing. So we're asking the question, is this program achieving the purpose that it's supposed to achieve under its enabling legislation? So whenever we create a program, there will be goals associated with that program. So in program accountability, we are looking at effectiveness. How effectively is this program meeting the goals that it is supposed to meet? So fiscal accountability deals with money and the spending of public taxpayer money. Process accountability deals more with the efficiency of implementation. Then program accountability deals more with the effectiveness and the consequences of these programs that we are implementing on the beneficiaries who are receiving those benefits. So how we impose ethical standards will depend upon which element of accountability we are focusing on. If we are focusing on fiscal accountability, obviously one of our primary tools will be the use of audits. And so we'll conduct financial, legal audits. And those financial legal audits will then allow us to see, is this money being spent in the legally appropriate manner? And that's what a financial or legal audit will do. For process accountability, this is where you may use something more like a management or performance-based audit. And management or performance-based audit, we will really look at kind of how we are spending the money, just not what we're spending it on, but how well we are spending that money. You know, is there fraud? Is there waste in terms of how we are implementing these programs? And then for program accountability, one of the best tools that we have is something you'll learn a lot more about in 696 research methods, and that's program evaluation. So program evaluation will really get us to answering that question of how effectively this program is achieving its stated goals and objectives. So the tools we use will really depend upon the type of accountability that we are focusing upon. So how do we ensure accountability? We ensure accountability by balancing external and internal approaches. The external approaches will be these ethical standards and these ethical guidelines that we promulgate for administrators to follow. So here are the rules and regulations that you must follow in implementing these programs and spending this public taxpayer money. Then you have internal forces, and those internal forces are the character and the training of the administrators themselves. So how much of a belief do they have in the public interest? Are they there for the right reason? Are they there to promote the public interest over their own individual private interests? How well trained are they in terms of the ethical expectations and what to do in case they see a violation of some of these ethical principles. So we need an external as well as an internal approach. The problem for us in enforcing accountability and ethics is that when there are ethical violations, they tend to occur within organizations themselves. It's hard for us from outside to see what's going on within that organization on a daily basis. The people who know what's going on a daily basis are those administrators who are actually within the organization. So what we need to do is we need to protect those individuals so that when they see ethical violations, they then feel comfortable reporting those ethical violations because they're the ones who see those ethical violations on a daily basis. So they need protection. If employees do not have protection when they see these ethical violations, they will not become what we call the voice. The voice is the decision by members of an organization to remain within the organization, but bring these ethical violations to light, to protest policies and programs and actions that they disagree with. So we hope these people will remain in the organization and will be the voice of ethical adherence. If they are not protected, then chances are they will exit the organization. They will leave the organization because they disagree with what's going on in the organization and they do not feel protected from reprisal and retribution. As I'm sure you all know, those individuals within organizations that point out these ethical violations are referred to as the whistleblowers. Whistleblowers take it upon themselves to disclose these activities that they believe to be wrong, that they believe to be unlawful, or they believe to be unethical. Fortunately, both at the federal as well as at the state level, we have protections built into federal and state law to try and protect these whistleblowers. And so let me go ahead and just stop the share here because usually when I click on links in the slides, it usually doesn't work all that well in terms of visually on the screen. So let me just briefly stop this share. And let me then share out a couple of websites for you. Let me just share my screen. That's probably the easiest way to do it. So let me share out my screen. And let me stop this share. Get this share out of here. Okay. Let me minimize this. We're getting there. Okay. Here is a website. Hopefully you can see Whistleblower Protection Act, Office of the Whistleblower Ombudsman. If you can't see that, let me know, but hopefully that should be on your screen. That is these are some of the details of the Whistleblower Protection Act. At the federal level, the federal government passed this Whistleblower Protection Act, and it has been reauthorized numerous times since it was originally passed back in 1989, 1990. And you'll see some of the details of the Whistleblower Protection Act. It prohibits retaliation against most federal executive branch employees when they blow the whistle on significant agency wrongdoing or when they engage in protected conduct such as testifying before Congress in this oversight type of process. And what you have here in this document, it gives you some insight into what types of things are covered, who's covered, what types of whistleblowing activities are covered, and then the process that's used to make sure that these whistleblowers are protected from reprisal and retribution. So who is covered under this Federal Whistleblower Act? Basically, the vast majority of executive branch employees, former employees, and applicants fall within this Whistleblower Protection Act. Employees of the Government Publishing Office, which is a legislative agency, are also covered under the Act. Who is not covered under these whistleblower protections? Political employees. Political appointees. So if someone is a political appointee, they are not part of the career civil service, they are not covered under this Whistleblower Act. Uniformed military service members are not covered under this act. Non-career senior executive service employees. We'll talk about what the senior executive service is in a couple more class sessions. In a couple of class sessions, we'll talk about career civil service and we'll talk about the creation of the senior executive service. But essentially, the senior executive service are members of the federal bureaucracy. They're at the highest levels of the federal bureaucracy, what we would call what used to be general schedule 16, 17, and 18 employees. So those folks who are up there at the highest level of management, those people are part of the senior executive service. So non-career members of that senior executive service. Employees of the 18 intelligence communities. Now, the reason why some of those folks are going to be exempt is because they have a separate piece of legislation that provides them some protections. But when you have national security issues at hand, you got to be very careful with those types of national security issues. And you can see some of those. We won't go through them all. Employees of the U.S. Postal Service is an interesting one because that's a government corporation. But those are the types of folks who are not covered under Whistleblower Protection Act. What can then be reported? What are some of the protected disclosures of information that are protected by this Whistleblower Protection Act? Any violation of laws, rules, or regulations, gross mismanagement of public resources, a gross waste of funds, an abuse of authority, a substantial or specific danger to public health or public safety. Those are the types of things that people have information on, they can then blow the whistle on and then have protection from retribution as a result of this Federal Whistleblower Protection Act. So when someone blows the whistle, what then happens? Who do they blow the whistle to? When they blow the whistle, they can blow the whistle to a variety of different places. One is to Congress, so they can reach out to Congress and say, here is an ethical or a legal violation, and bring that directly to Congress. Congress, through a legislative review committee, then can open an investigation and review that claim. They can bring their claim to this organization called the Office of Special Counsel, or the OSC. The Office of Special Counsel is an independent investigatory body that is charged with reviewing these whistleblower claims. So they will go out there, they'll investigate the claim, and then they can offer protections. They can come to a conclusion, then offer protections to that whistleblower so they are not demoted or they're not fired or otherwise getting some negative personnel action as a result of blowing the whistle. Offices of Inspectors General. In the Obama administration, there was a reorganization of the federal bureaucracy that required that every federal department and federal agency would have its own Office of Inspector General. And so an employee can bring their claim to their agency's Office of Inspector General, and that OIG in that agency can then review that claim. Sometimes you'll bring it to managers, obviously. To the media. Sometimes people just give it out to the media, and then the media goes and investigates it. Obviously, you would hope that you go through official channels, and usually the Office of Special Counsel is one of the best places to go, because the Office of Special Counsel has been doing this for many, many years and has some really well laid out steps and procedures that it goes through in hearing this type of a claim. So we won't go through it all, but you can read through it and you'll see, the types of things that you can claim in a whistleblower claim, the type of proof that is required to prove a claim, and the type of relief that is available. So if you feel that you have been retaliated against, some of the relief that you can get from the Merit System Protection Board through the OSC's investigation is reinstatement or transfer, which includes back pay and any lost benefits, reasonable and foreseeable consequential damages, and so medical costs or travel expenses, compensatory damages such as emotional distress, pain and suffering, damage to reputation, and attorney's fees and costs that you've had to incur, including costs incurred from a retaliatory agency investigation. So those are the types of relief that can be provided to you from the Merit System Protection Board as the result of the Office of Special Counsel's investigation. If you want to read more details about this Whistleblower Protection Act, you can look at our slides. In our slides, I have it linked there for you. So you can just click the link and it'll take you directly to this page. Fortunately for us here in California, the state of California also has its own Whistleblower Protection Act that covers state employees. And so this one is run through the California State Auditor's Office. And it's kind of weird here in that you can submit a claim to the state auditor, but then any type of relief that you get granted, it has to then go through the Attorney General's office. So you can submit it to the state auditor, they will look at your claim, and then they will usually transfer it over to the AG's office, and then the AG's office will follow through on the prosecution of the violations of the Whistleblower Protection Act. So you can see if you are a state employee, you report your retaliation by contacting the state personnel board in writing. If you're an employee of the UC, then you can contact your human resources department. If you're an employee of the Cal State system, then you can go through the chancellor's office or human resources through the chancellor's office over at Golden Shore here in Long Beach. How does it work? Well, here are some frequently asked questions that are kind of useful for us. Let me move my camera shot out of the way. What types of claims can the state auditor investigate? Any violation of state and federal law, including regulations by state agencies or employees, non-compliance with an executive order of the governor, a rule of the court, state administrative manual, or state contracting manual, any significant waste or misuse of state resources, including funds, property, and employee time, gross misconduct, incompetency, or inefficiency by a state employee. And to give an example of some of the things that the state auditor has recently investigated as a result of whistleblower claims, things like embezzlement, improper contracting, which we've already talked about tonight, the misuse of state property, typically using state property for private gain or for the private gain of others, conflict of interest. We'll talk more about conflict of interest when we get to the end of our discussion of accountability. But if you are in a reportable position, you'll have to fill out a conflict of interest form, and that's meant to disclose any potential conflict of interest that you have. Then if you do engage in a conflict of interest and you have not reported that conflict of interest, then obviously the penalties will be more severe. Improper overtime, overbilling for overtime, improper expense reimbursements. Someone who is a colleague of mine on the school board ended up getting charged with a felony for this one. And so this is a serious thing that the state takes very, very seriously. False time and attendance reporting by state employees. You can file a complaint anonymously, but if you file it anonymously, it becomes a little bit more difficult for the auditor's office to follow up with you, to interview you, and get the information that they really need in order to fully investigate your claim. Again, I've got this link on our Canvas site, so you can take a look at and get some more details, but it's just good for us to know that here in California, we also have this state Whistleblower Protection Act that covers state as well as, to a degree, local employees as well. Let me go back and share out our slides, and then we can continue with that discussion. Let me move some stuff around again. I'm beginning to need two monitors whenever I have a lot of things going on like this. Okay. So it's important for us to understand there is that Whistleblower Protection Act for the federal government as well here as in the state of California. So it's clear to us that in the public sector, the ethical standards tend to be higher than those in the private sector because we are managing public resources. Those public resources belong to the taxpayers, so we do need to be held to a higher standard. As we mentioned before, when people transition from the private to the public sector, oftentimes they are hit very hard with this shock of ethical upgrade, where they are really surprised and sometimes dismayed by all the different legal requirements they have to go through to do their job in their public agency. The shock of ethical upgrade, that higher level of ethical expectations in the public sector, can make it difficult to recruit new employees. And so it's important for us to strike a balance between hiring the most skilled administrators while at the same time ensuring that we are preserving the public interest through having these ethical types of standards and these ethical accountability mechanisms. And sometimes it does make it hard for us to attract people from the private sector. It is also sometimes hard for us to attract people from the private sector because of the sometimes negative connotations that are associated with the public service. Now, we are all in an MPA program, which means that we have a strong belief in public service. We want to be part of the public service. We want to serve the public interest. When I was chair of the department, I got to review all the applications to the MPA program. And as part of your application, you would write a statement of interest, or a statement of purpose, whatever they're calling it these days. And I would look at every one of those statements, and pretty much down to a person, every one of those statements talked about their belief in the public service, their belief in the public interest. So we as students in the MPA program, we have a strong belief in public service. That strong belief is not always shared by members of the general public. Members of the general public oftentimes look at government as being inefficient, ineffective, impersonal, full of red tape, corrupt. Usually you get these negative associations whenever you mention bureaucracy or government to members of the general public. Charles Goodsell, back in 1970, wrote his Case for the Bureaucracy, and he recognized this negative perception that the bureaucracy that government's held in by members of the public. His argument is that administrators need to become advocates for the public service. They need to go out there and advocate for the essential nature of the services that are being provided in the public sector. When you think about what government does, government touches just about every aspect of our lives, from the roads we drive on, to the cars we drive in, to the clothes we wear, to the food we eat, to the air that we breathe, to the water that we drink. Just about everything is touched by government action. In the absence of government, we would obviously have none of that. So it's important to underscore some of the positive ways in which the bureaucracy, the public service really enhances the quality of life of individual citizens. We have had some presidents as the most prominent public officials in the country who have gone out there and really made a concerted effort to promote public service. George H.W. Bush, he's a great example of this. He was a big believer in public service. He was a lifelong public servant. He referred to government service as being the highest and the noblest of all callings. Barack Obama, when he ran for president back in 2008, one of the cornerstones of his campaign was to try and make government and public service cool again. So we have presidents who believe in public service. They can really be a good mouthpiece, a good spokesperson for the vital nature of government and public service. We in the public service understand that public service, public administration is complicated. It is difficult. There are a lot of moving parts that we deal with on a daily basis in implementing even just one singular program. But we also know that if we do our jobs right, that public administration is a fulfilling vocation that has a potential to impact the lives of many citizens and to really make a profound difference in society. We just have to convince those outside of the public service of that fact. But to kind of add some tangible understanding of what types of things we are expected to do as public administrators and that are considered to be ethical conduct, that are considered to be ethical types of actions. We are all public administrators. And as public administrators, we have one organization that kind of unites us. And that is the American Society for Public Administration, otherwise known as ASPA. ASPA has been around for many, many years. The genesis for ASPA started way back with John Gauss in 1936. There are chapters of ASPA all over the country. There are local chapters of ASPA. There's several local chapters of ASPA here in Southern California. And ASPA provides for us an 8-principle code of conduct that we need to adhere to as public administrators. And this will form the basis for your essay and Canvas essay number 2. So the first principle here you see on the screen is public interest. We are expected as administrators to promote the interests of the public and put service to the public above service to oneself. That is the antithesis of what George Washington Plunkett told us to do in his Plunkett of Tammany Hall. So public interest comes first, and it comes above private interests. Number 2, and this gets right back to what we talked about last week and why we spend so much time talking about American government and the Constitution. We are expected to uphold the Constitution and the law. Respect and support government constitutions and laws while seeking to improve laws and policies to promote the public good. In order to respect and support a constitution or a law, we need to know what that constitution or that law says. But not only do we respect and support these laws, but we are also charged with trying to improve them and improve them for the purpose of promoting the public good. So last week was all about ethical standard number 2. Ethical standard number 3, to promote democratic participation, to inform the public and encourage active engagement in governance. Be open, transparent, and responsive, and respect and assist all persons in their dealings with public organizations. So the work we do in the public sector is the public's work. So it needs to be done in the public. It needs to be done in the open. We need to have great transparency and be very responsive to the public. When people come into contact with our organizations, we have an ethical expectation that we will help them in their dealings with our organizations. We won't make it more difficult. We will try and make it easier on them. This can sometimes be difficult. The more transparent we are, the more open we are, the more open we then are to scrutiny, and the more open we are to criticism. Serving on a board for 6 years, our public meetings, we have a requirement here in California that our meetings are open to the public. There are very few issues that can be done in closed executive session. Personnel types of issues, negotiations and conversations with your legal team, security types of concerns. Those are the types of things that can be done behind closed doors. For privacy and confidentiality reasons. Other than that, things have to be done in the open. And you need to have public comment periods so that people can have the chance to come in and have 2 or 3 or however many minutes to comment on both agenda as well as non-agenda items. The difficult thing, though, was to make sure you allow that public comment while still making sure that the meeting was the board's meeting. That sometimes members of the public will want to take over the meeting, and it's the board's meeting, but it's a board's meeting that's being done in the public. And that's a very important distinction. The fourth principle, to strengthen social equity. When we talk about public administration, we have several values that we adhere to: efficiency, effectiveness, protection of individual rights, representative bureaucracy, political responsiveness. But the one that has really kind of risen to the top in the new public administration in recent years is social equity. So we need to strengthen social equity by treating all persons with fairness, justice, and equality, respect individual differences, rights, and freedoms, promote affirmative action and other initiatives to reduce unfairness, injustice, and inequality in society. So this is what is referred to by Mark Moore, the Moore and Bennington article, as being an active public administrator, being a proactive public administrator, and adding value so that whenever a public organization implements a policy or a program, it needs to add value. And one of the ways it can add value is by promoting social equity and social justice. The fifth principle is fully inform and advise. This principle relates directly back to what we talked about with the principal-agent relationship and moral hazard. Provide accurate, honest, comprehensive, and timely information and advice to elected and appointed officials and governing board members and to staff members in your organization. We said there's a disincentive to providing this honest, comprehensive, and timely information because it makes oversight easier and adds more scrutiny to what you're doing on a daily basis. But we have an ethical requirement to fully inform and advise these policymakers as they make laws and as they make policies. Number 6, to demonstrate personal integrity. Adhere to the highest standards of conduct to inspire public confidence and trust in the public service. Here we are role modeling. One of the things that public managers, one role that they play that's not played quite as much in a private organization is what's called an expository role. Public managers play this expository role where they role model high standards of conduct, which will then inspire public confidence and trust. The more the public sees these high standards of conduct, the more likely they are to trust public administrators, and public organizations. Number 7, to promote ethical organizations. Strive to attain the highest standards of ethics, stewardship, and public service in organizations that serve the public. This is why the vast majority of organizations today will have a code of conduct. That code of conduct will be something that they review, hopefully on a frequent basis, but that code of conduct should then govern us in terms of our expectations of how we should behave, both with individuals within our organization as well as stakeholders outside of the organization. Number 8, to advance professional excellence. Strengthen personal capabilities to act competently and ethically, and encourage the professional development of others. That's an important qualifier there at the end. Encourage the professional development of others. All too often in our public organizations, we ignore training and development. We ignore opportunities to provide professional development to help people move into higher management levels. When we don't encourage professional development, we are not going to be able to have an effective succession plan. All organizations need a succession plan, especially today in the post-COVID world, where we not only have what's called the graying of the population, where we have a lot of our baby boomers are leaving, some of our Gen Xers are getting close to retirement as well. So we're going to see this turnover. It may not be a retirement tsunami, but there's certainly going to be a turnover in employees. That turnover in employees obviously was hastened by COVID-19. We had some people who, through COVID-19, decided, I'm going to try something else with my life, and I want to move out of this organization and do something completely different. And so we have seen a lot of turnover. That turnover means that we have to have a good succession plan in place. You cannot have a good, strong succession plan unless you prioritize professional development. So those are the 8 ethical principles in the ASPA Code of Conduct. For your Canvas essay number 2, you'll be reviewing these 8 principles, then selecting the 3 of these principles that you believe would be most difficult for either you or your organization to implement, and why you or the organization may find those principles difficult. So this kind of gives you the information you need then for your Canvas essay 2, which is due next week. But going back very quickly to the idea of being transparent, we know that in principle number 3, we promote democratic participation. We have to be open and transparent and responsive. Here in the state of California, we have a lot of laws on the books that require us to be very open and transparent when we are doing the public's business in the public sector. And you're probably familiar with some of these laws. We're not going to go through them in detail, but laws such as the Brown Act. If you work with a city council or any other type of legislative organization, then you're familiar with the Brown Act. The Brown Act covers those legislative organizations. The Brown Act requires that meetings must be conducted in public. So the vast majority of the issues that a governing board or a city council or a board of supervisors will need to deal with, those issues are dealt with in this public meeting, this meeting that is agendized, that is held in public. In those public meetings, you have to provide some time for public comment. Members of the public can comment on agenda items on the agenda. They can also comment on non-agenda items. However, the Brown Act precludes members of the legislative body from responding to public comments on non-agenda items. So if there are any items that are not on the agenda that members of the public are asking about, those cannot be responded to because that issue is not on the agenda. You can only discuss the issues that are on your published agenda. This leads to a lot of frustration among members of the public. And so members of the public will go up there and they will say, you know, governing board, I want to know why you haven't done this about this issue. Answer me. Well, that issue is not on the agenda. So we cannot answer that question. We are precluded from answering that question according to the Brown Act. If we would answer that question, it would be a Brown Act violation. Brown Act violations are then subject to what's called a cure and correct procedure. So if a member of the public says this board or this city council has violated the Brown Act, then they can file a claim with the Attorney General's office. And then if it's found that, yes, this was a violation of the Brown Act, then the remedy is that governing board or that city council must then engage in cure and correct, which means that at the next board meeting, at the next city council meeting, they have to fix the mistake that they made. And that's a cure and correct. If they don't cure and correct it, then there can be additional civil penalties for violating the Brown Act. So all meetings must be in public. The issues that are covered in public will be the vast majority of issues within the jurisdiction of that government. As I mentioned before, you can go into executive closed session where it's just the members of the legislative board. However, you can only go into closed session out of open session. So what a lot of organizations do is they will have a closed session, then followed by their primary open session. But in order to go into that closed session to begin with, they have to start an open session. So they begin an open session, then they'll say the board will recess into closed session with the anticipated return of whatever time into open session. So you can only go into closed session out of open session. The issues that you cover in closed session, as I mentioned before, are very limited in terms of their scope. So the issues you can deal with, personnel issues, you can deal with legal issues in terms of negotiations with legal representatives. This is one you have to be really careful about, because in order to talk about a legal issue in closed session, technically you need to have your legal counsel there. It needs to be a discussion with your legal counsel. Now, they may not have to be there in person. They may be able to be there on the phone or on Zoom, but you have to be discussing with that legal counsel. Negotiations. Sometimes those negotiations can be done in closed session, but the proposals have to be sunshine, which means that the proposals have to be read out in open session, but the negotiations can happen in closed session. Any action that's taken in closed session must be reported out in open session. So you can't take an action in closed session and then just not report it. You have to report it out. Now, if it's a personnel issue, so for instance, someone is subject to dismissal, when you report it out in open session, you don't use their employee's name. You would say employee number, whatever the numbers are, was dismissed by a vote of 5-0 or whatever the case may be. Agendas need to be published in advance, 72 hours in advance. They need to be publicly available. And then you need to adhere to the agenda. So you can only discuss the issues that are on the agenda. There are a lot of other elements of the Brown Act, but those are kind of the primary parts of the Brown Act that encourage open, transparent type of doing the public's business out in the view of the public. We also have a California Public Records Act here in California. If anyone throughout the course of your job, if you are the one who has to respond to these California Public Records Act requests, it can be a very time-intensive and very laborious type of process. I have linked a little fact sheet about the California Public Records Act. We won't share that out here, but suffice to say that any member of the public can make a request for public documents. The agency then has typically 10 days to respond to that request. Now, it doesn't mean the agency has to reproduce all of those documents within 10 days, but they have to at least respond to the member of the public within 10 days. That is a requirement. If this is a very labor-intensive request that you're going to have to go back years and years to look at. So for instance, a member of the public wants to know about all the contracts that were awarded to this specific contractor. Well, to be responsive to that request, you're going to have to go back through agendas and minutes for years and years. You have to go back through electronic communications. It's a lot of work. And so it's going to take you more than 10 days. So you respond back to the petitioner, say that we received the response. The finding these documents, securing these documents will take approximately, 60 days or whatever it is. And that falls within the parameters of the law. It's important to know that all communications that are responsive to this public records request also must be disclosed. That includes things such as text messages on the personal phone of a member of city council that is responsive to this request. Those would have to be disclosed as well. Just because it's on your personal device doesn't mean that it's shielded from disclosure. Anything that is responsive to the request must then be disclosed. What a lot of organizations will do is if it requires looking at personal devices, they'll ask a member of city council, do you have any text messages or any emails on your personal device that are responsive to this issue, to this public records request? Then if the person does, then they will submit those to the agency. If they don't have anything that is responsive, they'll say, no, I do not have anything. And then sometimes the organization will have that member of city council sign a legal affidavit in which they attest to the fact under perjury that they do not have any of these responsive documents. And so it's serious business to respond to these public records requests. Then, as we said, we need to avoid conflict of interest in our positions. And so California has a conflict of interest reporting mechanism in place. If you are employed in a reportable position, the form is Form 700, and that's a conflict of interest form. You'll need to complete this conflict of interest form, and you'll need to detail any potential conflicts of interest that you can have with the business of the organization that you are employed with. So, for example, you'll need to list any property investments that you have. Now, your personal residence, your primary full-time personal residence does not have to be reported on Form 700. But if you have rental properties, other investment properties, that needs to be reported. Any income that you are earning from sources or employers within the jurisdiction needs to be reported as well. Now, if your employer is located outside the jurisdiction and doesn't do any business with the jurisdiction, then that would not need to be reported. But any income you derive from within the jurisdiction or any employers that do business with the city or with the school district, that would have to be disclosed on your disclosure form, on your conflict of interest form. The purpose of Form 700 is to identify any potential conflicts of interest so that if a conflict of interest does emerge, that member of city council can then recuse themselves, not just from voting on that issue, but recuse themselves from the discussion as well. And this is all governed by the FPPC here in the state of California, the Fair Political Practices Commission. And the FPPC has a lot of specific guidelines that you can follow to try and avoid a conflict of interest. And they can get very, very specific. One example is when I was on the school board, the district was in negotiations with a developer for a school site that was literally within about 200 feet of the front door of my house. It was literally across the street from my house. I recuse myself from those discussions and from any subsequent votes because the result of those negotiations could have an impact upon the market value of my home. Now, I reached out to our legal counsel, and legal counsel said it's kind of a gray area. And my philosophy is if I can see the ethical line, I want to be as far away from it as possible. So I recuse myself from those discussions because if that parcel of property was developed in a certain way, it would increase the value of all the homes in the surrounding area. That would be a financial benefit that would accrue to me. So I recused myself and stepped away. It's important to try and avoid conflict of interest and even the appearance of conflict of interest whenever possible. So kind of wrap this discussion up because again, you'll cover accountability and ethics in other courses as well. This is just kind of an introduction to accountability and ethics in the public sectors. Accountability in the public sector really requires the striking of a balance. We need to balance the need of bureaucratic responsibility and ethical administrators, while at the same time allowing these administrators the flexibility and latitude to take risks and make good decisions. So we hold them accountable through these laws and rules and regulations, but we still have to give them some flexibility. So they're not afraid to be innovative and creative, that they're not going to be penalized for being innovative and creative. And we also have to strike this balance so that we can recruit the best and brightest into the public sector. It's always important for us to balance ethical adherence with the effectiveness of what we are doing in the public sector. Again, if you are too strong on ethics, it can detract from your effectiveness. If you are focused only on effectiveness, then you're probably going to be cutting some corners and you're not going to be adhering to ethics. So it's really very much this balancing act. And if we balance this correctly, then we'll be able to meet the demands of the public. Because at the end of the day, in the public sector, to be effective, we need to meet the demands of our constituents, of our beneficiaries. And so we really have to balance ethical adherence with meeting the needs of the citizens that we are intended to serve. So that is a very quick overview of accountability and ethics in the public sector. Again, I've got some links on the slides. I just added an updated set of slides about 3 hours ago to our Canvas site. So if the slides you're working from don't have those links in them, the ones on the Canvas site will. So in your leisure, you're certainly welcome to go and follow those links and get a few more details on things like the Whistleblower Act, the California Whistleblower Act, what the California Public Records Act says, and all those details are available for you. Okay, it is 5:30. So are there any questions or observations or clarifications on any of this information that we have covered for the past 90 minutes?
I just have a quick question. What was the third approach to accountability? I think I missed it.
Sure, yeah. The third approach is evolving policy problems. It essentially means that every organization has its own unique organization culture. So when we put together ethical rules and regulations, we need to do that recognizing the different expectations and cultures in each organization. So one set of ethical guidelines that might work for one organization may not work for another. So it's a very contextual approach to enforcing ethics in the public sector.
Oh, okay. Yeah, I got that. Sorry, I thought it was a part of the political challenges that there were different cultures within the organization. I see now. Okay, I see the separation. Thank you.
Sure. Yeah, we usually deal with that as a third one. The political challenges is kind of the recognition that there is no clear line of demarcation between the political world and the administrative world. So it's not as easy as saying, well, if an administrator is playing politics, that's unethical. We can really no longer say that because that bleeding over of politics and administration. That's kind of the political challenges, that second approach to accountability. Good. Good questions. Anything else before we take a quick break for tonight? Okay. Let's take a break until we'll take a break till 5:45. That'll give us a little bit, give about 13 minutes. Come back at 5:45 and then we'll get into our breakout groups. I have an exercise for us to do in our breakout groups. Spend about 30 minutes or so in our breakout groups, then reconvene, see what our groups came up with, and then I think will take us through in enough time for tonight, and that will probably finish up our session. So take a break, come back at 5:45, and we'll do our breakout groups. All right, everybody. Well, welcome back. Hope you had a good break. Sorry, my cat is kind of coming on the desk, so I'll take care of that. That's one of the drawbacks of working from home, I guess. All right, let's do our breakout groups. I know I had promised you that I would like to get you out a little bit early tonight in case you wanted to watch the debate. And I know I talked a little bit more than I thought I would in the first half of class. So what we'll do in this breakout exercise is instead, I usually like to give you about 30 minutes to work in your groups, but I think now we'll probably for tonight do about 20 minutes, if that's okay, just so we can then reconvene, see what you came up with, and then call the night a little bit early. But for this breakout exercise, what I would like for us to do, and I'll put you into groups of probably 3 groups of 6 people each. I want each group, once you're in your breakout group, to consider a recent example of an ethical violation in either the public or the nonprofit sector. So this could be something that you witnessed, or it could be something that is something was on the news, in the media, something high profile, City of Bell, something like maybe if you want to do something at the national level, Bob Menendez and his trial, or George Santos, or there's no lack of ethical violations that have been covered in the media. So just as a group, think about one that you would like to focus on. What happened in that situation? What types of ethical principles you thought were violated in that example? And then how would you as a group, how would you have addressed the issue and probably addressed the issue differently than how it was addressed in the media story? So pick an issue, pick an incident, what happened in the incident, what ethical principles were violated, and then how would you have addressed it differently? I would like to ask that each of our three groups, if you could select a spokesperson, because we'll work on this for about 20 minutes, then we'll reconvene, and then the spokesperson from each group will share out your answers, and then we'll call it an evening. So that's our exercise we're going to do in the breakout groups. Let me go ahead and set our groups up real quick. So we're going to set up three groups, and I'm just going to do this randomly and automatically. So of our three groups, it looks like we have 6 people in each group. So I'll go ahead and open up the groups. I will give you a 5-minute warning when we have 5 minutes left, and I'll give you a 2-minute warning, and then we'll wrap it up and reconvene as a class. Let me open the rooms. They can go into your breakout room, and we'll work on the breakout room assignment. So here we go. Okay, the rooms are open, so you should be able to enter your assigned room.